Malta introduced the current legislation on trusts in 2004, and it's played a tremendous role in building up Malta as a financial services sector. Today with me I have Dr. Priscilla Mifsud Parker, who is the partner for Families and Wealth at Chetcuti, Cauchi Advocates. Priscilla, if you can start by explaining to me, how does a trust work in Malta and what are its unique selling points compared to other jurisdictions that also have trusts?
So, trust law in Malta was implemented in a civil law jurisdiction because essentially our basis is that of civil law. So, it was implemented in a manner which complements the Trust Institute as a common law institute, but also other civil law institutes. The advantages with having a trust is, first of all, the asset protection purposes, so that's one of the advantages which we can achieve. And there is also the estate planning side of it. So just as an example, we would use the trust in scenarios where we have assets which need to be protected, including valuables, real estate, family businesses, and depending on the settler's wishes, we would draft a trust deed in order to make sure that his initial intentions are then carried out. In the case of family businesses, for example, we would use a trust in order to make sure that once the family business passes on to the next generation, the family business per se is owned by the trust, and if there is any dispute between the siblings, then the family business is not dismantled, because essentially they are not the owners and therefore they cannot decide just to dismantle the whole business.
Well, that means that the trustee actually has an awful lot of power but also responsibility. So explain to me first of all, what are the components when setting up a trust? You've clearly got the trustee, and how would you choose a trustee to make sure that they can actually fulfill this role?
So it is very important to choose a trustee who is authorized by the authority in the country where we are setting up the trust. In the case of Malta, trustees are authorized by the Malta Financial Services Authority, which is the regulator here. It is also important to look at the directors of such company, and in Malta, for example, the law provides that there needs to be more than 2 directors in order to ensure continuity.
Now, you've mentioned a couple of the things that trusts are used for, but perhaps you could give us a few more examples. You said family business, estate planning and so on, but are all of these transparent situations? Clearly people are very worried about reputation nowadays.
The trust itself is a confidential arrangement, so it is set up through a trust deed or a unilateral declaration, or if it is a trust which will take effect upon the death of the settler, then it would be set up by a will.
So is there a time period for trusts? How long are they valid for?
For inter vivos trusts, so trusts which are set up during the lifetime of the settler, they are valid for 125 years.
Okay, so it's really across generations.
Yes. So
which obviously is an advantage for them.
Yes. It ensures that assets are passed on from one generation to the other without having to go through the probate process. So essentially the next generation would be the beneficiaries. They would benefit from the assets, but they are not directly the owners of the assets.
So really, this is where the choice of the trustee would be very important for protecting the reputation of the people who set up the trust, I assume.
Yes, definitely. And it is also very important to note that trusts are used for different family scenarios. So they are essentially a tool which we would use for the benefit of people who also require assistance in the management of their assets. So, for example, if we have a person who is unable to manage his own assets, or a child who is unable to manage his own estate, then it is very good that the parents prepare for the eventuality of their death by setting up a trust for the eventual benefit of this person.
Are there actually any tax benefits associated with trusts, or?
Local tax benefits, there aren't any. So the trust itself is neutral in terms of the tax consequences that it creates. So domestically we use trusts in order to protect assets mainly from any separation, especially in situations where siblings are not agreeing between themselves. and also in order to protect them from any eventual claim. It could be a claim where basically a client doesn't feel that they are being serviced well, or they received a faulty product, etc. And by putting assets into a trust much beforehand, you are then protecting these assets in a separate patrimony.
Very interesting. Okay, but how would one actually go about setting up a trust? Is it a very complicated process?
It is not a complicated process. The important thing is that the initial meetings between the trustee and the settler are held in order to determine what the intentions of the settler are.
Because they could give different levels of power. Presumably there's quite a lot of flexibility.
Yes, there is.
And they should take advice on that, presumably beforehand, so they understand the implications.
Yes. In fact, the process entails a first meeting or a first call in order to determine what the requirements are. After we determine what their intentions are, then we would choose a type of trust. So we can have a fixed interest trust, for example, or we can have a discretionary trust, which gives more leeway to the trustee of how they can manage the assets in the best interest of the beneficiaries.
Thank you, Priscilla. Clearly, this is a very complicated subject, and there's a lot more information that I'm sure you would be interested to find out. This was just a little bit of a teaser to explain to you the broad concepts. If you need any other information, there is plenty of expert advice and even written material available from Chetcuti Cauchi advocates. I hope you'll get in touch.